welcome to IAS Origin. So today we will be talking about the most important verdict of Supreme Court on Article number 370. Whether the abrogation of Article 370 by the Parliament in the year 2019 was constitutionally valid or not. And the decision has been given this week. And the Supreme Court verdict has upheld the abrogation of Article 370. Article 370, the most controversial article of our Indian Constitution. Under this article, the state of Jammu and Kashmir was given a special status. Yes, Jammu and Kashmir, which had special rights regarding itself. इंडिया में एक सिंगल सिटीजनशिप एंड सिंगल कॉन्स्टिट्यूशन का कॉन्सेप्ट फॉलो किया जाता है. दैट मीन्स देयर इज अ सिंगल कॉन्स्टिट्यूशन फॉर होल ऑफ द यूनियन एज वेल एज द स्टेट्स, अनलाइक यूएसए जहां पे स्टेट्स का अलग कॉन्स्टिट्यूशन रहता है एंड फेडरल कॉन्स्टिट्यूशन अलग होता है. बट in case of Jammu and Kashmir in India, Jammu Kashmir had its own separate state constitution. So these were some of the privileges available to Jammu and Kashmir under this article. As a result, time and again, this article was in controversy. And a most historic landmark judgment was passed on 5th of August in the year 2019 when Article 370 was abrogated from the Indian Constitution और जम्मू कश्मीर का special status हटा दिया गया था. From there onwards, the controversies started. Whether this is constitutionally valid or not, because बात की जाए Article 370 की, then there were 3 options available for removing it, and the options were, because the way this was abrogated was very diplomatic and crucial. We can see, if we want to remove Article 370, there were 3 options available. First option was Article number 368 of the Indian Constitution. Yes, Article 368 बात करता है amendment लाने की. If you have to bring the amendment, then a law is passed, which has to be passed by both the houses, Lok Sabha as well as Rajya Sabha, by a special absolute majority. But the government did not adopt this method, and the reason was the time this bill was passed, उस समय लोकसभा में गवर्नमेंट की मेजॉरिटी थी बट राज्यसभा में गवर्नमेंट की मेजॉरिटी नहीं थी. As a result, this amendment might have failed. Therefore, this option wasn't used by the government of India. And the second option available was the Article 370 itself. Article 370 में mentioned है that Article 370 can be revoked by a presidential order. एक president order pass करेगा, उसके through revoke हो सकता है. But one condition, that presidential order must be signed by the Constituent Assembly of the state of Jammu and Kashmir. Yes, जम्मू कश्मीर की स्टेट असेंबली से उसे साइन होना चाहिए. बट द थिंग इज कॉन्स्टिट्यूएंट असेंबली ऑफ जम्मू एंड कश्मीर हैज डिसॉल्व्ड. वो एग्जिस्ट ही नहीं करती है. कॉन्स्टिट्यूशन फ्रेम करने के बाद इट गॉट डिसॉल्व्ड. नाउ दिस ऑप्शन वाज आल्सो नॉट अवेलेबल टू द गवर्नमेंट ऑफ इंडिया. When these 2 options were not available, the approach adopted was very diplomatic and bureaucratically planned. Now, government adopt a 3-pronged approach. It first amended Article 370, then amended another article got by 367, and then again to Article 370. Now, the government here first amended Article 370 by an ordinary bill. They said that all the articles of the Indian Constitution were now to be applicable to the state of Jammu and Kashmir. Earlier, only 2 articles were applicable. One was Article number 1. That is, India, that is Bharat, shall be a union of states. Means that Jammu and Kashmir was a state and was a part of the Union of India. Another article that was applicable to Jammu and Kashmir was Article 370 itself. Now, the Article 370 amendment stated that Article 370 के अंदर पूरा का पूरा Indian Constitution अब जम्मू एंड कश्मीर को अप्लाई करेगा. This resolution was passed. Then another article was picked up and that was Article number 367. Now we talk about Article number 367. Article number 367 के words हैं interpretation of the Constitution by the Parliament. Means कॉन्स्टिट्यूशन में जहां भी एम्बिगस प्रोविजंस हो, जहां पे क्लैरिटी नहीं है, then parliament interprets the constitution. So here the government interpreted that the word constituent assembly, Article 370 mentioned that presidential order pass karoge and it must be signed by the constituent assembly. So they interpreted the word constituent assembly of Article 370 with the word state legislature. Yes, now they said any presidential order signed by the state legislature will come into effect. But now here the controversy is, at the point of time of this bill, state legislature तो वहाँ existence में था ही नहीं. Yes, the state legislature was dissolved and the state of Jammu and Kashmir was under Article 358. 356 के तहत President's rule operate कर रहा था in Jammu and Kashmir. So how this act has been passed? Is it valid or not? This was a major question since then, and finally the Supreme Court has given its judgment. So today in this video, we will be talking in detail about whole act that was passed in the year 2019 as well as the Supreme Court's verdict that has been given. But before starting on to our topic, I would like to welcome you on IAS Origin and would like to tell you that you can enroll with us for prelims cum mains program, where you will get live classes, current affairs PDF, personal mentorship session and the personalized strategy plan based on your needs. Let's begin. Article 370. This was an Indian constitution gave special status to Jammu and Kashmir, जहाँ पे उनकी खुद की citizenship हुआ करती थी, state citizenship. There was a different constitution, especially for the state of Jammu and Kashmir. They were also given special rights. For example, they had their own fundamental rights. No one outside the state could buy the property in the state of Jammu and Kashmir. उनकी properties, उनके jobs reserved थे for the people of Jammu and Kashmir only. So some of the important provisions were given over there, which provided a special status to Jammu and Kashmir. This 370 was based on the terms of instrument of accession. Now when we talk about Jammu and Kashmir, at the time when India got independent, option was given to all the princely states, either to join Pakistan or India or remain independent. Jammu and Kashmir was under Maharaja Hari Singh and it chose to remain independent. But then there was an attack and encroachment of Pakistan. As a result, Maharaja Hari Singh signed the instrument of accession and thought to join hands with the Indian Union and become a part of the Indian Union. As a result, this instrument of accession was signed, but Article 370 की condition पे, that is, Jammu and Kashmir would get a special status. This was done to provide a ease of integration with the whole of union. Since वहाँ की conditions बहुत different थी, the culture of the people and the demography of the people was quite different. So as to ease the accession process, this article was signed. But at the time this was adopted, Article 1 was considered as a part of Jammu and Kashmir. But at the time this was signed, Article 1 को एक important part माना गया था. Means they integrated with India holistically. That means they were part of the Indian Union. Now, so how this Article 370 got repealed? The procedure that was adopted by the government. First was presidential order. As I said, Article 370 was mentioned. In Article 370, it was mentioned that after passing a presidential order, Article 370 can be repealed. So first of all, presidential order was passed in 2019. Provision giving a new meaning to the Constituent Assembly. And the interpretation was done under Article 367. As I said, that Constitution Assembly means the Legislative Assembly of Jammu and Kashmir. Now, as I said, Jammu and Kashmir was under President's rule under Article 356. So here the State Legislative Assembly's role was played by the President of India. And President of India literally means Parliament of India or the Government of India. So this was how this bill was passed. President order लाया गया means the government passed the bill and this bill was passed and the president signed it, and this bill was passed by Lok Sabha and Rajya Sabha in place of the State Legislative Assembly because उस point पे president's rule impose कर रहा था. And second is resolution in the parliament. Then this concurrent resolution was passed and both Rajya Sabha and Lok Sabha gave its nod on 5th and 6th of August in the year 2019. Then third thing which was what was along with abrogation of Article number 370, another act was passed, that was Jammu and Kashmir Reorganization Act. Now, whole of Jammu Kashmir state, this state was divided into two parts. One was Leh and Ladakh region, which was named as a union territory of Ladakh. And another part was considered with Kashmir, which was termed as the Union Territory of Jammu and Kashmir. Now, Ladakh was to be constituted as a Union Territory without the Legislative Assembly and Jammu and Kashmir as a Union Territory with State Legislative Assembly. So, the whole of state was divided into two UTs. These were the three provisions that were what in 2019. But this brought many questions before the Supreme Court. Whether Article 370 was temporary or permanent, whether the procedure adopted by the Parliament was valid or not, means interpreting Constituent Assembly as State Legislative Assembly and the State Legislative Assembly's role being played by the Parliament. Was it valid or not? Another question was that Parliament decreasing the status of a state to a union territory was valid or not. Because if we talk about Article 3 of the Indian Constitution, states' recommendation and permission is required when you change the boundaries of a state or alter the boundaries of a state. But this was not done because वहाँ पे assembly already existence में नहीं थी. It was dissolved. So all these questions arose, and as a result, the Supreme Court had to intervene, and this landmark judgment was passed. Now we'll be what all rulings are being given by the Supreme Court. They upheld the validity of the abrogation of Article 370. But what were the comments made by Supreme Court? Is Article 370 permanent or temporary? Over this, the Supreme Court specifically said that Article 370 was a temporary provision. It was done only to ease the integration process. As I said, demography वहाँ की बहुत different थी, and there was a huge turmoil at that time. So as to ease the process of integration, this was signed as a temporary provision. Second was, is parliamentary procedure adopted valid? Because if we see on to parliamentary procedure 368, normal amendment process adopt नहीं किया गया. Presidential order adopt करके इंटरप्रेट करके कॉन्स्टिट्यूशन में चेंजेस लाना, कॉन्स्टिट्यूएंट असेंबली को स्टेट लेजिस्लेचर, was this valid or not? So over this, the Supreme Court, the CJI, Justice Chandrachud, said that President in Jammu and Kashmir case can assume all or any role of the state legislature, can assume all of roles. Justice Chandrachud here said that whenever a state is under president's rule, president or governor can take any decision. In normal states, the governor takes decision on behalf of the president or the government of India, and those decisions cannot be called in question before the court. But here, since governor was not there, it was president who was to take the decision, and such actions cannot be called into question in the court of law, because if this happens again and again, then there are so many decisions which have to be called. Over here, Supreme Court took the reference of one of the landmark judgment, that is SR Bomai case. Yes, SR Bomai केस में प्रेसिडेंट्स रूल आर्टिकल 356 की वैलिडिटी चेक की गई थी. दैट इज अगेन एंड अगेन इम्पोजिंग प्रेसिडेंट्स रूल, इज इट वैलिड और नॉट. उसमें ये कहा गया था, अंडर एक्स्ट्राऑर्डिनरी सर्कमस्टेंसेस प्रेसिडेंट कैन टेक देयर डिसीजंस एंड दैट डिसीजन वुड नॉट बी कॉल्ड इन क्वेश्चन. सो दिस वाज द Supreme Court stance over this. Third question was, concurrence of the state government isn't required. Now, as I said, आप एक स्टेट का स्टेटहुड डिक्रीज करके यूटी का स्टेटहुड ला रहे हो. आर्टिकल 3 में स्टेट्स परमिशन इज रिक्वायर्ड, बट द कोर्ट हियर हेल्ड दैट द एक्सरसाइज ऑफ द पावर अंडर आर्टिकल 370 क्लॉज 3 ऑफ द कॉन्स्टिट्यूशन यूनिलेटरली स्पेसिफाई. आर्टिकल 370 में मेंशन्ड है, प्रेसिडेंट ऑर्डर से यूनिलेटरली स्पेसिफाई कर सकते हो. सो हियर दिस प्रोविजन एंड दीज वर्ड्स वर यूज्ड, दैट यूनिलेटरल प्रोविजन पास किया गया था. ऑल्सो आर्टिकल 3 में जो रिकमेंडेशन स्टेट की होगी, दे आर मियरली रिकमेंडेटरी, वो सेंट्रल गवर्नमेंट पे बाइंडिंग नहीं होती है. दैट मीन्स पार्लियामेंट के पास ओवरराइडिंग एक्सक्लूसिव पावर रहती है टू ऑल्टर द स्टेटस ऑफ अ स्टेट एंड reorganize the states. Fourth was, upheld the 2019 law. Now 2019 law means Jammu and Kashmir Reorganization Act. The court upheld that act and it carved out the union territory of Ladakh out of the state of Jammu and Kashmir. The government or the parliament has the right, it can carve out a particular part of a state to give it a special status of union territory to meet the needs and aspirations of the people over there. So this was also upheld by the court. Another question, Parliament is not a mere law-making body during President's rule. Now here Supreme Court said, जब President's rule impose होता है किसी भी state में, Parliament is not a law-making body. It can also bring about executive resolution. Different orders ला सकती है for the good governance and for the and to deal with the extraordinary situations. So this extends to executive action. Another ruling was, conduct elections and restore statehood. Now here the Supreme Court said that in the Legislative Assembly of Jammu and Kashmir, you said that Jammu and Kashmir will be a UT with Legislative Assembly. So conduct the election as soon as possible, and the deadline was given as 30th September 2024 से पहले वहाँ की Legislative Assembly पे elections कराए जाएं. This is a verdict given by Supreme Court. And next it said to restore the statehood. Over this issue it said that Parliament has the right to form a UT out of a state, but decreasing the status is valid or not, Supreme Court has left the decision over the Parliament. Parliament will decide, and it has consulted Election Commission to look into this matter of the feasibility of making Jammu and Kashmir a UT or not, and if not, then grant the statehood of Jammu and Kashmir as soon as possible. This has been said by Supreme Court. That means restoration of statehood. And the last one is establishment of the Truth and Reconciliation Commission. Now here, this is very important. Since we know that Jammu and Kashmir time and again violent actions hote the, time and again terrorism and extremist activities have been witnessed since 1947 till date in 2019 when this bill was passed. Such a huge era. Whole of the youth of Jammu and Kashmir has been stuck in these violent situations. So they have been alienated from the mainland and the government of India. As a result, Supreme Court said to establish a Truth and Reconciliation Commission. That means the use of soft power to get the trust of the people over there. So this is also a suggestion of the Supreme Court. So all these were the rulings of the Supreme Court. But why this judgment has been passed? Many a times this abrogation has been termed as a political manifesto of the ruling party, because again and again in various political agendas it stated that Kashmir was a main issue. But apart from that, this was an important move, because if we talk about, there are many benefits. For example, integration and development. Till now, only the people of Jammu and Kashmir could get jobs over there and land over there. They were not able to integrate with the people of the mainland India. As a result, there was a sense of alienation or differentiation and discrimination over there. Now, this will bring about an inclusive and a holistic development over there by integrating it with the whole of India. Second is the national security. When we talk about Jammu and Kashmir, it has been a contested area. Pakistan lays its claim over POK, Aksai Chin wala area, over the China. So it is a buffer zone between Pakistan and China and the bordering state of India. As a result, to maintain the national security over there, the stronghold of the union government was very much necessary. As a result, for the national security reasons, abrogation was a good step. Then is ending separatism. Over there, time and again, violent actions and separatist tendencies have been raised, demanding to get away from the Indian Union. So this could now be better managed by the Union government. Earlier, when such actions were being undertaken, when the Union government and our armed force went to suppress it, many innocent lives were also lost, because whenever a war conducts, some innocent lives have been lost. As a result, sense of alienation generates, and this leads to separatist tendencies. So now merging with the Indian Union would end these separatist tendencies even. Also, of the transparency and accountability will be brought. Now, if we talk about integration with the Indian Union, सारे के सारे laws apply करेंगे Indian Union पे. Earlier, if we talk about Jammu and Kashmir को जितना special status नहीं मिला था, उससे कहीं ज़्यादा parliament की act पे ban था implementation होने पे. But now after integration, all the acts, be it CVC's rule, Central Vigilance Commission, be it RTI Act, सारी की सारी Jammu and Kashmir पे applicable होगी. And after this application, CVC, RTI जैसे acts के, transparency will be brought, because many a times there is a corruption in the government bodies and the bureaucrats. Now, after passing of this bill, this will be brought under the purview of all the acts, and the corruption will be reduced, bringing about transparency and accountability. Fifth is the holistic development. Overall economic development would be generated, and it would bring about prosperity in that particular state. So we can see that definitely this has been a positive signal for these points. Nonetheless, it had been passed diplomatically and very tactic process, but it has emerged out to be positive. We can see it with the stats also, because if we talk about 52 months before the decision was passed in 2019, the terrorist activities, the attacks on civilians injured was so high. And after 2019, this is drastically reduced. See, from 765 to 455, from 193 to 156, there is a drastic change. Means we can say that there has been a reduced violence and separatism in Jammu and Kashmir after the passing of Act in 2019. Also, if we take about the economic outlook, then after 2019 when this bill was passed, the revenue of the government rose from Jammu and Kashmir. Yes, revenue receipts वहाँ से बढ़ गई हैं. And we can see that this is a COVID year, 2021. So here the receipts are less. But after the COVID year, they have drastically increased. So economically भी ये benefit कर रहा है government को. Therefore, we can say that integration of Jammu and Kashmir is a positive step and has been welcomed by Supreme Court and has been upheld as a constitutionally valid process. So that was a whole analysis of Article 370 abrogation and the Supreme Court verdict. Hope you liked it. Do like and comment, and for more such videos, subscribe to our channel IAS Origin. Thank you.